Look at these 3 words written larger than the rest, with a special pride never written before or since. Tall words proudly saying, "We the people."
Good evening, folks. I'm Alexander Haberbush, president of the Lex Rex Institute and a practicing constitutional attorney. And this is another entry in our video series, Ask an Attorney. I apologize that it's coming out a bit later than usual. Usually we get them in on Friday afternoons. I did have a lot of work today, so just now getting to it. But hopefully you're able to watch it anyway. I guess that's, if you're hearing this right now, then you're already watching it, so you're able to. So I guess that's sort of a silly thing to observe. But as always, while watching this, keep in mind that nothing in this video or any of our other videos constitutes legal advice. With that out of the way, let's go ahead and dive into this week's question. Does every law have a punishment for violating it? All right, this question sort of gets to the distinction between the civil and the criminal law. And just to give a broad overview answer to this question, no. Not every law does have a punishment for violating it. However, every law does have a remedy for violating it. Not every remedy is a punishment. Punishments are going to apply in the criminal sphere, while other things will apply in other spheres. You also have other things associated with criminal penalties. A penalty is sort of a synonym for punishment, but other remedies will apply as well. But to explain how that works, I'm going to have to take a few steps back. So let's take a real bird's eye view approach on this. I believe I've explained in a past video, in fact I think it was last week's video, but it may have been the week before, not entirely sure, that law only relates to 2 kinds of things. That's it, just 2. Only got to know 2 things to be a lawyer or know the laws. What does law relate to? Well, it relates to rights and it relates to wrongs. That's it. That's all the law is, rights and wrongs. Rights are the things that it's right for you to do, and wrongs are the things that it is wrong for you to do. Obviously, because we live in a free society, a liberal society, we say that we are free to do something unless that thing is explicitly prohibited. So our rights, there are many of them, doesn't mean that it's a great idea for you to do everything that you have a right to do, but it would certainly be within your rights to do it. Whereas wrongs are those things that are explicitly prohibited. So that's our broad, big picture distinction, rights and wrongs. Then within wrongs, we've got 2 different kinds of wrongs. We have public wrongs and we have private wrongs. Sorts of wrongs that have punishments associated with them are going to be the public wrongs. So what's the distinction here? Well, private wrongs are going to be things that are dealt with under the category of what we call the civil law, whereas public wrongs are going to be dealt with under the criminal law. So what does that mean? What is this public rights versus public wrongs versus private rights and private wrongs? Well, let me explain to you basically how that works. So here's a quotation from Blackstone's Commentaries on the Laws of England. We looked at this book before, but he says that private wrongs or civil injuries are an infringement or privation of the civil rights which belong to individuals, considered merely as individuals. Public wrongs, or crimes and misdemeanors, are a breach and violation of the public rights and duties due to the whole community, considered as a community in its social aggregate capacity. So what does that mean? It's a lot of big fancy words to describe what I don't think is that complicated of a concept. So private wrongs, those are going to be things like breach of contract, anything under contract law, anything in the law of torts, which are going to be things like negligence or battery or defamation, which recently came up in the Amber Heard and Johnny Depp trial. That was tort trial for defamation, so that was a private wrong. So private wrongs are going to be things like that, things that are between 2 parties, things in which society has no interest. So basically, there's no reason why society ought to get involved in those things at all. Now, originally, public wrongs were things that would be prosecuted by the crown, by the king. And basically, the theory there was that if somebody commits a public wrong because the king is in charge of the entire public, that's a wrong against him. Therefore, he has a right to have a lawsuit against that person. Nowadays, our sovereign is we the people, and we appoint our chosen representatives of the people in our governments. So the lawsuit is going to be by that government against the person, either by a state, so you might have state of California versus John Doe, or by the federal government, which is going to be U.S. v. John Doe. So that's the way that criminal suits are going to work, whereas civil suits are going to be between 2 different parties. That might be Depp v. Heard, something like that. So how does this work? Well, how does this break down? Well, how do we know? I guess the broader question, more specific question is, how do we know which things are going to be public wrongs and which things are going to be private wrongs? How do we know whether or not society is harmed by something or whether it's just somebody involved as an individual? Well, let me explain that by way of a couple of examples, because I think Blackstone's explanation of is not just that it involves individuals, but it involves them as individuals, not as their individual connected with the broader society. So say that I had a house that I was selling to you, and let's just say that your name is John. It makes it easier for the purposes of this illustration. So your name's John, and I'm selling you a house, and I want to sell that house to you for $20,000. And you agree, you signed a contract saying that you will buy that house from me for $20,000. Well, the due date to pay that money comes due, and you bring $20,000 worth of salami. And you try to get me to convey that house to you in exchange for $20,000 worth of salami. Now, I, in my negligence, was not real specific in the contract language used. I did not say $20,000 in US dollars. Nevertheless, I refuse to accept your salami as payment, and I won't give you the house. That would be a private wrong. If you were to sue me for that, if you were to say that I have to convey that house to you because you fulfilled the contract, that would be a private wrong, because society has no stake in which of us owns the house. It makes no social difference whose possession that house is in. That's not something in which society has any interest. So, and obviously there's a valid dispute here. Was your $20,000 worth of salami actually a payment of $20,000? We don't know, because the contract was a little bit ambiguous. I think the court's probably going to rule against you, but that's, for the purpose of illustration, I think you see what I mean here. What would be a public wrong involved here? Well, that would be, say somebody broke in to the house that was owned by either of us because they were trying to steal stuff from that house. Well, that's not the sort of thing in which we can really have a civil society. You can't possibly have a civil society that will subsist where actions like that are permitted to escape consequence. You can't have people just breaking into houses and stealing stuff with impunity. Society is implicitly interested in that. Now, you may be interested as an individual as well, but the whole community, considered as a community in its aggregate capacity, also has an interest there. Another example. So, say that Sally is a masseuse, and Paul visits Sally for a back massage. And he agrees that he's going to get a back massage from Sally. She agrees to provide it. They exchange money, and then she starts to give him a back massage. Day later, he realizes his back really, really hurts. It doesn't stop hurting. It keeps hurting for a long, long time. So he sues her, saying that you caused this injury to my back. Is this a private wrong or a public wrong? Well, that would be pretty clearly a private wrong, because A, we don't really know what happened here. We don't know if the back massage is what caused the harm to Paul's back. And secondly, this is a dispute that is purely between the two of them. Society doesn't really have an interest in how Paul's back was injured here, assuming that Sally provided this back massage in accordance with basic, trying to perform a back massage, not trying to actually injure the guy. Whereas if Sally did try to injure the guy when she gave him the back massage, if she was intentionally, I'm going to do it in a way where I know it'll screw his back up for years and years, that would be criminal, because we can't just have masseuses going around trying to injure people. Very different situation, very different sort of law that would apply. So that's the civil criminal distinction. And to answer the original question, only criminal laws are going to have penalties. We punish criminal offenses. Civil offenses incur civil liability. That is, you may owe something to the other party if you lose. That's not a punishment. That's just what that person is rightly entitled to. Now, we do have what's called punitive damages that you can get in some civil lawsuits. But even there, we don't just call it, a punishment, even though punitive is rooted in the same word as punish. We call it punitive damages because it's really classifying the kind of damages that are awarded. Still going to call that a civil liability, civil penalty that's being imposed. But that's the distinction we're looking at. So no, by no means all laws don't necessarily have punishments, but all laws do have remedies. And this traces back to that Latin phrase, it's ubi jus ibi remedium, which means if there is a law, there must be a remedy, or there is a remedy, rather. And this is actually reiterated by Alexander Hamilton in Federalist number 84. He says, it is essential to the idea of law that it be attended with a sanction, or in other words, a penalty or punishment for disobedience. If there be no penalty annexed to disobedience, the resolutions of commands which pretend to be laws will in fact amount to nothing more than advice or recommendation. And we actually have had Supreme Court cases on that. If there is a law that prescribes certain conduct, there has to be a remedy that somebody can get. Now, he's probably mostly talking about the criminal law here, which is the reason why he refers to it as a punishment. But regardless of which kind of law is in play, there's got to be a remedy. If there doesn't appear to be a remedy, it's actually open to constitutional challenge, because this ancient maxim of ubi jus ibi remedium must continue to apply in all of our laws. Now, there are currently some laws where that doesn't appear to be the case. For instance, if the police violate the knock and announce rule, saying that when executing a warrant on somebody's house, they've got to knock and announce first before breaking down the door. Well, they do no-knock raids all the time now. Technically illegal, but there's no suppressionary rule for any evidence that's obtained. That means, ordinarily if police violate your civil rights, then they can't use any evidence obtained by doing that in court. They got to exclude that evidence. Well, here, for failure to follow the knock and announce rule, they don't exclude the evidence. So that would appear to be a law where there is no remedy. And that may be open for challenge. The Supreme Court hasn't come up yet, though we would certainly be open to bringing that kind of a case. Hopefully that answers this week's question. Tried to be brief in this one because it is, I know, late in the evening, and I know you don't want to watch a 20-minute video right now, so hopefully that answers the question. This has been a presentation of the Lex Rex Institute. Thank you so much for watching.